Hello, UCAR. Peter Christensen here, coming to you from the CEO's desk. Going to talk to you today. It's still March. We're still talking about contract law basics. So, going to talk to you about earnest money. So, it's a big part of our contract, but what role does it fulfill in the contract? So, a couple thoughts there. I know a lot of agents talk about consideration. One of the necessary elements of a contract is something they call consideration, which means something of value is being put on the line, and that helps form the contract. Well, a lot of people will tell you earnest money is the consideration. It could be considered consideration. That's probably should be rewritten, considered consideration. But if you don't have earnest money, your contract can still be valid because the exclusive right to purchase the contract can be consideration. So let's get that myth out of the way. Can it count as consideration? Yes. Does it have to? No. If you have no idea what I'm talking about, look back at your old real estate school booklet, and it'll talk about consideration in a contract. Okay, but it is an important security element. So nobody wins in a lawsuit. And if things go wrong in a contract, what do people do? They have to sue each other to make it right. Well, they don't have to. That's why we've built in this liquidated damages clause into the contract. So earnest money becomes a predetermined amount of damage. So the parties decide this is the amount of earnest money we'll put in there, and then it becomes the default. This is what will be paid out if there's a breach of contract by either party. Okay, so quickly, what happens if earnest money is not paid? So the contract by default says now that you'll give it 4 days after acceptance of the offer, right? The buyer will give it. And big question there. What happens if it's not? Well, you've got a promise in the REPC that's going unfulfilled. That's the technical definition of a breach of contract, a promise that is unfulfilled in the contract. So what does that give the seller the right to do? It gives the seller the right to cancel the contract, seek damages, all that kind of stuff. So would you say that's a pretty material defect? I would. If it gives the seller the right to cancel, then it's probably pretty material to the contract. What does that mean? Well, it means that if it's not given, then the buyer's agent has a duty to disclose that fact to the seller, because state law, code of ethics say you have to disclose material defects in the transaction. That would be earnest money and a lack thereof. So have that conversation with your buyer, not at 4:00 p.m. on the deadline day, but as they're filling out the offer, let them know, don't put me in that position. I have to turn you in. I have to notify the other side if we don't have it. So let's get it in on time. And that has to be delivered to the brokerage by the deadline, not put in the mail. So that's earnest money in a nutshell. It goes to show you put $500 in there. Will $500 really cover the damages done if there's a breach? I don't know. You decide, but the more in there, definitely the more likelihood there is that you avoid a lawsuit, because it's enough to cover damages. That's the purpose behind it. So hopefully you take that into account. That's earnest money in a nutshell. Thanks for tuning in. If you guys have other topics you wish I would hit, leave a comment below. We can look at trying to incorporate those. Otherwise, have a great day.